Welcome back to another episode with the legendary Keith Mitnik, or the Outsmarting series. Really pumped for this one. We have some definitional items that you want to discuss.
I do. What I want to do is we'll pick up where we left off. We just didn't have enough time to finish. Too big of a topic to finish last go around. And remember, in the last episode, we talked about part of this teaching about or explaining how the civil justice laws work was the distinction between an accident and negligence. The underpinning of the civil justice code or the civil justice laws is it is not permitting people to act unreasonably. They have to use reasonable care for the safety of others. The single word for that is called negligence. People generally don't know what negligence means. It means failure to use reasonable care. That's what it means. It means you got to be careful, not super careful, but you can't be careless. You got to use reasonable care. And the simple word that the judge will explain to jurors is negligence. If someone violates that law, they act negligently, and it causes harm. Then we switched, as we talked about last time, now we move into the second phase where we're now assessing what is the full value or for what was lost in the way of health, what was taken as a result of injury caused by the negligence. So people...
Well, hang on. I don't want to take that for granted. I want to just stop you there. Accident versus negligence. Can you impress a little bit more on why those are important distinctions?
I'd be glad to, because it's everything. The defense side loves to say it was an accident. If you were to take a little counter in the courtroom and listen to the number of times the defense says the word accident, you would probably break the counter. You can't keep up. Why? Because we were all brought up hearing some version of this. Accidents happen, which means it's no one's fault, which means there should be no consequence. There should be no punishment. Now remember, this system has nothing to do with punishment. We are not punishing the negligent person. So you take punishment out. It is a system for safety. It demands a certain reasonable level of care. And if you don't, and someone ends up hurt as a result of that, then we fully and completely recognize the full extent of harm caused to that person. What is the harm caused because of the negligence? Not to punish, because once there's negligence in the third party that happened to be out there, that got hurt because of the negligence, that person should have a remedy. The remedy is full recognition of the harms and losses caused by the negligence, not punishment. We're now focused on the harms and losses caused. Now, therefore, this whole point of view the defense loves, which is it's an accident, is to suggest accidents happen, it's no one's fault, it's part of human nature. That is wrong. Yeah, that's right, by the way. It's just not, you will not find the word accident in the civil justice laws in any state in America, to my knowledge. Certainly not in any of them I've tried cases in, which is a whole lot of states. So, what's the distinction now? Because some folks may be saying, what's the difference, accident and negligence? What's the difference? Don't they talk about accident reports? Doesn't the police officer say the accident occurred on so-and-so date? Yeah. The word accident is made it into the ticket writing side of it. People call it an accident because people said, man, it's not on purpose. But now we're in a court of law. We're now enforcing the civil justice laws. And that loosey-goosey language has no place. Now, can you stop the defense from using it? Probably not. People file motions to try and say you can't use the word. Judges say they can say what they want. But you shouldn't if you're on the side representing them. The judge shouldn't, and most won't, because it isn't the standard. It's negligence. So what I'm making a big deal out of it, because I remember right now sitting there, I can remember my dad, my brother and I chasing each other around the house, and we knocked a lamp over. And my dad, who had a hot head, and I can remember my mom saying, Nick, honey, it was an accident, to settle him down. because he was going to wring her neck. We all have a story like that. That's why the defense loves it, because they want to slip into the punishment on purpose state of mind, which has no place in a civil court of law. It does in a criminal, but they want it to be more like, oh, you're going to, like we did it on purpose. So what is the difference? Technically, not just I don't like it. What's the difference under the law? What's an accident? A clumsy dancer steps on his dance partner's toes. A young kid who doesn't have ball control is throwing to his daddy and he overthrows his glove and breaks the neighbor's window. That's an accident. Someone runs a red light and T-bones someone and changes their life. Is that little kid throwing that baseball and doesn't have ball control? Is that clumsy dancer who stepped on his dance partner's toes while he's trying to, swirl her? It's night and day. Negligence is an official wrong under the laws of civil justice. It is something that rises to the level of an official wrong under the law. Not an accident of a little kid. Not a clumsy dance partner. You violated the civil justice laws. What you did was not bad enough to be on purpose or you'd be in criminal court. But it's not an accident. It's bad enough to be qualified as negligence. You did not use reasonable care for the safety and well-being of the other people on the road with you or in that department store or wherever you were, or a doctor for the safety of their patient, or a product for the safety of the people you're making money selling the product to, or a drug for the safety from a pharmaceutical company to make sure you're not causing harm you're supposed to be helping, unreasonable harm. And if you don't take reasonable care, it's not asking too much to use reasonable care. It's not some ridiculous standard. We teach our children to use reasonable care. We may not use that word, but you say, be careful, honey. And if you're not using reasonable care and you hurt someone, and most of the time it's an adult, by the way, or it's a 17-year-old driving a car, by God, if you got a license to drive a car, you better use reasonable care. I don't care if you aren't of the legal age to buy a beer. You ought not be you're being unreasonable. What is it? Let's stay in the car crash. It's a 50-mile-an-hour zone and you're doing 75. That's not reasonable care. Do people do it? Yes. If they hit someone and change their life, you trigger this system that, remember, it's about safety and remedies.
So how do you price the accident? How do you price that? The negligence, rather. How do you price the negligence?
I'm going to change the word price. And there are a lot of lawyers who would say it is, you price it. I don't. Just because it starts sounding like it's a business transaction. And this is not a business transaction. Because when you price something, you go to the store to buy it, you are intentionally taking that product home and paying something for it. And the person who's selling it is happy to get your money for you to take that product home. It's a intentional, informed business decision.
Wow.
This isn't a business decision. Someone was driving to go pick up their kids from soccer, and someone who wasn't using reasonable care, who ran through a stop sign, who pulled out and didn't look both ways. They didn't see you. They didn't pull out and purposely said, I'm going to ram you. But they pulled smack out in front of the guy on a motorcycle who's now missing a leg. Why? Because they were in a hurry and they were trying to rush out and they looked one way, looked the other, because they were trying to get through the center and go across 2 lanes of traffic and never looked back. Well, you know what? Reasonable care is, you know better. Look back. Someone could have come around that corner and be there. So if you didn't use the reasonable care and now someone got hurt because of it, that person was minding their own business. And this injury now is thrust into their life, not from an accident. It was thrust into their life because someone wasn't doing their job of following the rules of reasonable care on the road or wherever it happened. So what do we do with that? I don't say price it. I say assess it, value it. We bring jurors in from the community to sit as a group of appraisers, and they assess the full value of what was taken in the way of health. It's not about how much they're going to get. That's the idea. Oh, we're going to celebrate. They're going to get a bunch of money. They'd love to have their health back. They don't want the money. They want their health back. That's not an option. So what are we going to do about it? We've decided what we're going to do about it. We got a civil justice laws that tell us what we're going to do about it. We're going to recognize completely the value of what was taken in the way of health, what was lost in quality of life, enjoyment of life, how their health and experience of life baseline was dropped forever. If it's a permanent forever injury, a lifelong injury, they're never going back to here. And they can't go back there. That's not an option. So we take that loss. If this was your baseline and now you're here, we take what was lost and say, what is the reasonable value of that? How do we tell? Is there a formula? Does the judge say, here, I'm going to hand out a sheet for each of you so you can calculate it? You can do that on loss of income. You can do that on medical bills in the past, in the future. You can't do that on the impact on pain and suffering, on what I call human damages. So how do we do it? We gather people from the community to sit together and use their collective wisdom, and they say, I'm listening to the evidence, the judge has given me these baseline instructions, but after that, we're going to put our heads together and decide, was that a big loss? Was it a teensy loss? Was it a medium loss? And then we're going to attach a numerical amount, a dollar figure to that. That is the piece of when I say it's about safety and remedies. The remedy is not a philosophical debate who was right and wrong on the road that day. The remedy is money. We're in the business of getting a remedy, and the remedy is money for what was lost. But it is not jackpot justice. My client doesn't want to pull the lever. They didn't want to be here. It was happened to them. Someone was violating those safety rules, and they changed their life. And we don't turn a blind eye to that. That's no justice at all. So we gather people from the community to sit in judgment and say, I'll tell you what's a fair and reasonable amount. And the lawyers make suggestions. Here's what we would suggest to use a fair and reasonable amount. And if the lawyer's doing their job, they're going to give them reasons to back it up. They're going to show, here's how I came up with it. I didn't just pull it out of the air. I'm going to give you some reasonable measuring sticks that I suggest you consider. You don't have to accept them, but I suggest they make sense. And then you better be making sense. Not just throwing some number you want. You better have spent time thinking, what is fair and reasonable? Look, you can't say to the jury, what if it was you, but you damn sure as a lawyer can say it to yourself. What if it was me? And what if it was me and it was prospective, looking forward? It hadn't happened to me yet. What would be a fair and reasonable amount to say, we're going to take this health from you. We're going to do this to you. But before you agree to it, here's how, let's have a discussion about what would be fair and reasonable. I promise you it's a significant amount if it's a significant hurt. That's what we do.
Yeah, that's wise.
But that's a significant part. That is an essential part. So people go, oh, now money's come up. Now I was all with you about the importance of this safety system. But it's not a one-part system. It isn't a shame on you system. And it isn't a punishment system. It is a system with a remedy. Because remember, there are two parts. Someone got hurt. Someone did wrong. They violated those rules, and someone got hurt. Once we show the harm, the wrong, the violation, and it caused harm, now what are we going to do with the person who was minding no business and got harmed? We're going to fully compensate them, not discount justice. Well, since when was America about discount justice, half justice, small justice? Justice is about, America's about big justice if big justice is justified. If it's not, then it's small justice because it's a small injury. And there's some small injuries. Thank God. I wish they all were. But there are a lot of them that aren't.
Just to tie this together as we wind this episode down, you're such a nitpicker on these definitions and the beautiful distinctions that you've come up with. When you were younger in your career, were you making these kind of sloppy vernacular issues,
Sure.
and then that's how
Sure.
you learned it?
Sure. If I look back, I remember somebody had an audio cassette. This will show you how long ago it was. When I was still in law school, and they had some program where you could try cases when you were still in law school at public defender, state attorney's office. You were supposed to have oversight from a supervisor. My situation, I won't go into detail, but I was kind of flying close to solo. I had a little help. And the lady who was the secretary in this misdemeanor department where I was working, I tried 7 jury trials, still in law school. I hadn't gotten out. Criminal cases. Said, I was 15 years later. Said, you're not going to believe. She reached out to me. Somehow I didn't even remember her name. She remember I was, oh, yeah, how are you doing? I was digging through some old things I had, and I found a cassette. They had cassette tape. No court reporter. This was in county court. They had cassette tapes. They taped the proceedings. There wasn't a court reporter even there. He said, I've got a tape of your first closing argument, your first trial ever. I bet you'd like it. I said, absolutely. And I couldn't wait to get it. And I thought, it's going to be rough. I know it's going to be sloppy and rough. I had no clue, but I bet it's going to be good. I'm going to have fun. I listened for about 30 seconds and turned it off. I couldn't take it.
Wow.
I won, but it was.
That's
I guarantee you, when I started doing civil and I got out, I used accident. I get all kinds of things wrong.
That's so comforting to hear, though.
Oh God, my dad, who I don't want to turn it into a daddy issue, but my dad never watched me play football, and I was a good football player, and he never watched me as a lawyer. And he finally came once. I was young, still had all my hair, young, and I did jury selection in a med mal case. I mean, I don't know, year and a half, 2 years out of law school, and doing a med mal case, by myself. And he comes over, and we're in the middle of all this tort reform, and people can't get babies delivered because all these ambulance chases. And they showed lawyers, fat lawyers, playing poker and smoking cigars. It was ugly, ugly. It was all over the TVs, trying to get tort reform and the public behind it. And we had a room full of people who were just rabid against this med mal case. And I developed all these systems in part because of that. And you know what I did? I tried to convince them how all those ads were wrong, that they'd all seen, and how, it's not that way. And I didn't accept, respect their feelings and get them to acknowledge this isn't the right case for them. They got a bias against it. So they would leave, and we could get people weren't tainted. Not they're tainted like in bad human beings, but they have a right to their opinions. They just shouldn't be deciding that case. But I didn't have a clue. I just went in there and argued with them about how they were wrong. And it was bad. My dad came for that. It's the only thing he ever saw me do.
Goodness gracious.
As a lawyer or as an athlete.
Oh, God.
And afterwards, I hear my mom, I was over visiting like a week later, I hear my mom say, Nick, not now. And I lost the case. And by the way, no one had figured out how to do it back then. All this stuff has been developed since then, how to establish cause challenges. I shouldn't say no one I knew. The guys trained me didn't know it. But my dad wasn't one to be reined in. So he takes me outside, and I say, I had no idea, but I knew it wasn't going to be good because I heard my mom saying, honey, not now. And he says, I just feel I have to tell you, the way you handle that jury selection was all wrong. And now he starts telling me what's wrong about it. And he never saw me again. Then he passed away.
Goodness gracious.
So we all have our driving forces.
Yeah,
he was. I don't mean to make my dad say he was a good man.
Yeah, and you took it to heart, and you've.
But I learned from it.
Yeah.
So the question is to younger lawyers: Are you going to do it just right? No, you're not going to do it just. I still don't do it just right, by the way. But I dang sure did it less right back then. It's okay. It's part of the process. But you know what? If you believe in what you're doing and you come with a smart game plan. If someone had told me, don't do it that way, do it this way during juries, I may not have been pretty doing it, but I'd have done it right. It may not have been perfect, it may not have been polished, but the plan would have been right and it would have been maybe a different result. But so come with a good plan, learn from folks that have got more years under their belt, listen to it, come with a good plan, go talk with experienced people to make sure your plan's a good one. and bring your integrity to the courtroom and that you believe in the cause, you'll be fine. It doesn't need to be perfect.
And with regards to the process, how do you get the jury to buy into trusting the process?
It's these conversations. You know how you do it? You respect them. You talk straight. And if you explain, they don't understand the process, most of them. But you know what? Most of them are smart people. If you take the time to talk to them within the boundaries of what's permissible, and then they go, oh, I understand. There are some say, I hear you, but I ain't buying it. This is all a money grab. Okay. Just then ask the right questions, establish cause challenges so they're not on your jury. And then if you see them in the hall, sit and chat with them. They're good people. They're just not good for your case. But talk straight to them. And then some that are neutral and maybe aren't really against it, they just don't understand. They go, you see them, you start having these kind of conversations and you start seeing them go, you start explaining why we have the remedy. They start going, okay. You start saying things like, in America, we don't do eye for an eye justice, but we also don't believe in turning a blind eye to justice. That's no justice at all. You know what they go? All right. What we do is gather people from the community, sit as a group of appraisers and assess the loss. They go, well, that makes sense. And all of a sudden, the mystery of it goes out the window, and the reasonableness takes its place. And now we got a chance to have a fair and just result, which is a thing of beauty.
Love it. So just to recap, we learned about accident versus negligence and how important those words are. We don't want to use the word accident. We don't want to use the word pricing. We want to use the words assessing. We're taking people from the community. Also, it's okay for young lawyers to make mistakes.
Absolutely.
Really vulnerable.
You ain't going to get better if you don't.
Yeah. Thank you for sharing that. And
by the way, my first book, Don't Eat the Bruises, was not a book mostly of victories. That was me healing. When I had a bad outcome, it was me figuring out how can I do this better.
Wow.
So you'll get better. But you can still do your job. Get in there and do it.
Yeah. And then getting the jury to trust the process by talking to them straight.
Always be straight.
This was great. Thank you so much.